Welcome, ladies and gentlemen, non-binaries, and anyone who identifies in any manner. This is the final session of the MBE crash course. And I wasn't even going to do an extra session this week, but it was so important to me that we all left feeling really confident and really great. So as I was showing the class, I've added some new resources. One we can start with is these flashcards, and the flashcards are all on the drive as PDFs, or if you have Anki software, I could share these decks with you in Anki form. So let's start with contracts. Let's see what we got, a couple of them, and let's just see what the class thinks. What's the definition of a contract? That's too easy. It's going to be an agreement between two or more parties in which there are valid remedies at law, right? Offer, acceptance, consideration, no valid defenses will be the elements of contract formation. Okay, here's a good one. What special rules apply to merchants under the UCC? Does anyone have any ideas?
Firm offer rule or other foreign provision.
Good faith under
No consideration necessary for modification.
No consideration necessary for modification. We talked about the firm offer rule. We talked about valid of foreign provision. We talked about maybe if there's a anticipatory repudiation, a merchant will have 30 days to respond to a request for further assurances. See what anyone else in the chat says. Perfect tender, confirmatory memo. Good job, Hannah. Lost volume profits.
And the 10 days to object with the confirmatory memo.
10 days to reject to the confirmatory memo, and 10 days to reject to an additional term under the UCC if they don't like it. So let's see what we got here. Merchants have special rules such as valid of forms, the firm offer rule, no consideration need for modification in good faith, 30-day request for further assurances, and the written confirmatory memo rule. Pretty solid. Very happy with everyone. Can you provide an example of a third party specified in a contract? I like to say like two brothers, and we have an agreement to pay our father $100 a month. I pay 50, my brother pays 50. My father would be a third party identified in the contract. Let's see if I'm like my father and I just say the same thing over and over and over again. A third party, sure, that's me. A third party specified contract can be an explicitly named beneficiary, any person or organization clearly identifiable in the contract, right? There's even a question where it's like, I will pay $100 to anyone who you find to buy this car from, right? That anybody is identifiable because if there's someone sells them the car, then they were identified in the contract. Let's do one more. What is the mailbox rule? Anyone have any thoughts about the mailbox rule?
acceptance upon dispatch.
Right.
Revocation upon receipt.
Yeah.
Yeah, and then if revocation is sent first and then acceptance, whichever is received first.
Under the mailbox rule, an offer is effective upon receipt, while acceptance is effective upon dispatch. If a rejection letter is sent followed by an acceptance letter, whichever arrives first is effective. If anyone watches Keeping Up with the Kardashians, Kim really struggled with his mailbox rule, and I think I could be the one to maybe clarify it for her. If anyone knows her address, they could put some mail in her mailbox saying I could help. Hey, one thing I wanted to talk about, Omar, are you with us?
Yes, sir.
Is there any report on your overall weight loss program / study program?
Started at 217.8 down to 197.5.
Look at that, man. Sounds like what, 20 pounds, man. Look at that. So anyone out there who wants to study and shed weight, all you need is a treadmill and the password to class. So what is the concept of tortious interference with the contract? Tortious interference with the contract refers to the intrusion of a contractual relationship by someone. That one really hits home for me. Okay, let's see if I can go through some other decks just a little bit and then we'll move forward. I think Civ Pro is important because people tend to not do very well at Civ Pro. What is a writ of mandamus? I have in the chat, yeah, to make someone do what they should, right? To make an official do something. It's interesting how the people who work in criminal justice know this one. It's interesting how people who work in the field know about their field. A court issue that was at issue in Marbury v. Madison, right? Little Marbury v. Madison, but right, the writ of mandamus is like a court ordering someone to do something. What is supplemental jurisdiction?
That's how you get a claim into federal court.
Exactly. That's how you get a claim into federal court. So supplemental jurisdiction is when a federal court can hear a state claim that is part of the same transaction or occurrence as another claim that satisfies the requirements for federal question jurisdiction or diversity jurisdiction. What is a default in a case?
When a party has failed to make a motion or an answer within.
Yeah, inactivity or something, or, you know, just being lame. What is diversity jurisdiction? $75,000, and every plaintiff and every defendant is different. Is a default the same as a default judgment? No, a default is an activity in the case that results in a warning, while default judgment is the actual judgment on the merits. What is a pretrial conference? Is EJ in the class today? I know he's a busy guy. No.
Parties meet with a magistrate for like the timeline of the case.
Yeah. And EJ, if you watch this in review, this is a shout out to you. His name is Manifest Injustice, right? Because to amend a pretrial conference order, you need to show manifest injustice. We love rap albums in this thing. A conference to talk about the case after the complaint and answer, discuss discovery, interrogatories, etc. Are default judgments with or without prejudice? They're with prejudice. How is a person's place of domicile determined? Person's place of domicile is determined by their home state where they intend to remain, where they live, and where they intend to reside indefinitely. If someone's in college but plans to come back home, their domicile is their home state. Let's do one more. When can clerks instead of judges issue default judgments? Let's see if anyone says one. Right, some certain. Clerks can issue default judgments when there's some certain, such as a breach of contract case. No, Brighton, a default judgment is with prejudice, right? Yeah. Can pretrial conferences be modified? Does anyone know what the standard is to modify a pretrial conference? Does anyone listen to me?
Manifest injustice.
Yes, to prevent manifest injustice. That's what this test is all about. If you can just amend pretrial order with manifest injustice, match summary judgment with genuine dispute of material fact. You know, if you can play the matching game, you're going to succeed. Let's look at some. Name and describe one exception to the exclusionary rule.
Where the government would have found out on its own either way.
Inevitable discovery exception. This exception allows evidence that was illegally obtained to be admitted if it would have never been discovered through lawful means. So I know what everyone's saying. Wow, these flashcards are super amazing. I wish I had more access to them. Like I said, you do have access to them in our drive. You just go to the crash course and we'll put this on the main MBE drive too, like the whole thing. And you can just open up these flashcards. I turn them all into PDFs and you can continue to go through them. I think they're super valuable and I would recommend doing that. I showed everyone my cram guides, you know how to access them. These are great things to go through, right? Hours billed is not a confidential communication that's privileged. Unavailability of evidence and admissibility of evidence in general is a question for the judge, not the jury. Remember, the judge determines whether something is admissible and the weight of the evidence is a question for the jury. There's no such thing as animal or machine hearsay. Hear that, Rosie? You can say whatever you want. It must be a statement made by a person, not a dog reaction or speed timer. The best evidence rule, improving the terms of a writing, recording, photograph, or x-ray with terms of material, the original writing must be produced. People struggle with the best evidence rule, but the way I see it is if the thing itself is in question, we're going to need to bring it in. A good example is a libelous letter. Like apparently, allegedly, you wrote some messed up stuff about me. Please don't say messed up stuff about me. I work really hard to let people love me. So let's say you guys say some libelous stuff about me. And I'm like, yo, this dude said some libelous stuff about me in this letter. What would the jury want to say? Show me the letter, right? Like, come on, you can't just always say it. Like, yes, personal knowledge on some things. A different example is, let's say we want to know how much money you paid at the grocery store. Do we need to bring in the receipt? Or can the teller say, I have personal knowledge and it was $50? They could say that. You don't always need to bring in the best evidence. It's really if the thing is in dispute and we need to figure that out. Just another shout out. This is from Sam Collier, the amazing Sam. Sorry, I can't. I'm in bar prep. If you want a super cute shirt like that, she's also gonna be making an Ibis prep shirt, she said. So, shout out to Sam. Live, learn law. That's her at. Prior bad acts could be admitted to prove the defendant's conduct if offered for some other purpose than to show that the defendant is a bad person. We call this mimic, motive, intent, mistake, lack of mistake, identity, common scheme or plan. They definitely test a lot about mimic. I would say overall, murder, hearsay, and mortgages. Triple down on those three subjects. Triple down on homicide. Know the difference between murder and manslaughter. First, second, third degree murder. Voluntary and involuntary manslaughter. We've got some new rap albums out there. My man Nico came out with adequate provocation. You slap, I stab, right? Because you're adequately provoked by slapping to stab. And then his second follow-up album, I walked in on my wife with the pool boy. These are adequate provocation that results in voluntary manslaughter. Involuntary manslaughter is like, texting and driving, criminal negligence. First degree murder is a specific intent crime. Make sure you're pretty sharp on the specific intent crimes, right? What is it? Can someone please give me the mnemonic? Even a bar student can fake a laugh for ridiculous bar facts, something like that. Let's see. So the first three would be attempt, conspiracy, and solicitation, right? A student can attempt, solicitation, conspiracy. Those are going to be specific intent. And then always, which is going to be, in my opinion, the A should stand for assault, because assault in some circumstances can be specific intent. There's two theories of assault, but it could be A for assault. Then a student can always fake. The F could be for fraud or forgery or false pretenses or first degree murder, right? A student can fake a laugh even for, so the E would be embezzlement. So all the theft crimes are going to come in. The E for embezzlement, the F for false pretenses, the B for burglary, because you have to intend to commit a crime therein. And then the F, remember, like first degree murder, fraud, forgery, something like that. And then that's it, bar facts, right? So just remember the specific intent crime. First degree murder is a big one, but make sure you realize if they say the word murder, they're not telling you anything. If they say the word murder, it could be first degree murder, premeditated. It could be second degree murder, which in most jurisdictions is everything else, felony murder or depraved heart murder or intent to inflict great bodily harm. It could be any one of those general intent types of murder. When they say murder, it could be principal in murder. It could be accomplice in murder. It could be accessory after the fact to murder. All those people could still be found guilty of murder. So if they say, can Tommy be found guilty of murder? You have to know Tommy could be an accomplice, a principal, or an accessory, and murder could be first degree or second degree, and it could be specific intent or general intent. There's just, if they say Tommy is guilty of murder, there's a lot of considerations that go into that thought process. And then if it says homicide, well, it could be manslaughter too, voluntary or involuntary. So here's a tip for the MBE. Before the start of the test, write your shortcuts on a sheet of paper real quick, right? I agree with that. Things that'll help will certainly help. And just get to your test and just dump down some of these little mnemonics that you're never going to remember ever in your life, unless you want to work for Ibis Prep. And then, keep it on your test. Work through the test confidently. And if you learn anything or verify anything or sharpen anything as you take the test, document that so you can potentially use in a later question. At your lunch break, I do think you should review the cram guides. It's not going to help you that much, like, oh my God, I remember that directly from the cram guide from 30 minutes ago. But it will help you just stay sharp and reinforce. And it's just like anything, I grew up, I was a wrestler. That was my most successful sport. And I always used to know if I was going to destroy my opponent based on his body temperature, right? If he was cold, I was going to pin him in 5 seconds. Like, see you later. I'm going out, we're going to party tonight. If he was sweating and warm and he was ready for that action, I'd be like, oh man, we're in for one, right? Because that's competitors. Competitors don't go into things cold. You hear that all the time. So you do want to sharpen up, do some questions during lunch, do some questions in the morning, get your mind rolling so that you don't go in there and have a complete frozen brain, because you don't know how many students either start off terribly or finish terribly. We don't want that to happen. It's like a race. You want to be sweating at the starting line and you want to run through the finish line. Okay. So I showed everyone the cram guides. I think this is an amazing thing to go through, before and after, and just reinforce. We just did this review. Let's kind of review real quick. De novo, abuse of discretion, harmful error, when do they apply? De novo is just questions of law and you're looking at things brand new for like the first time. Abuse of discretion, we're looking at like a plain error. Like it was the lower court who let some evidence in that they certainly shouldn't have. And then the other things that we could have are clearly erroneous or harmful error. Clearly erroneous is for a bench trial, and harmful error is for a jury trial findings of fact. Elements of NIED, so it's just, you know, negligence, and it has to usually result in some physical manifestation, but, you know, look to see what the jurisdiction says in the question. And it's very similar to IID, but just with negligence. And then bystander elements, you're looking for being in a zone of danger. That's the best answer. Or there'd be a close familial relationship, and they actually perceive the event. Testimonial versus non-testimonial statements, we were saying that testimonial are things that you think that will be used in the courtroom. A great example is emergency. If you're like, help, there's an emergency, la-di-da-da, that's not testimonial. If you call the, you know, police station 3 hours later to talk about things, that's probably testimonial, and that's going to implicate the confrontation clause of the Sixth Amendment. When is it okay to discriminate based on alienage for not being a citizen of the state? Here we're talking mostly about things that are actions that are processes that are necessary to government function, like to serve on a jury, to be a candidate for office, or things of that nature. May you explain this up by them? So the phone call thing is like this. If I call someone and say, hey, I'm Tommy, that's not reliable. If you call a number that's only been given to 5 people by Tommy and he picks up and says, hey, it's Tommy, that's reliable. Recording statutes, pure notice, right? Bona fide purchasers. Race jurisdiction, first to record. Race notice, you have to have both elements, first to record and bona fide purchaser. Priority of mortgages, PMMs are at the top, and then depending on the jurisdiction, first to record or the bona fide purchasers will prevail. Liens are just like a way that someone can attach an interest to a property, like a mechanics lien or construction lien, and then they can perfect the lien and force the forced sale of the property. Remember that construction liens, mechanics liens, if there's a homestead exemption, there are types of things that can pierce that. And then impeaching for prior convictions or arrests, we said that if it's for, you know, dishonesty, it's coming in. If it's not, then it has to be, you know, related, or they have to open the door and give you, you know, a reason to bring it in. We talked about substantively that these things can be brought in for mimic purposes, motive, intent, mistake, lack of mistake, identity, common scheme or plan. We had some really great thoughts in the group chat too. Like we said that we did say that for a commerce clause, you have to have the channels, instrumentalities, and economic activities that in effect have a substantial effect on interstate commerce. We talked about the 5 things that are immediately appealable: collateral orders, class actions, extraordinary writs, qualified immunity, and injunctions. We talked about this important piece from Amy, that hearsay declarants who do not testify may be impeached in the same manner that they did testify. We said that the statute of limitations has expired, but the lender agrees to a new discharge. There's no new consideration needed because, you know, their agreement to pay the barred debt will constitute consideration. A little mnemonic: San Francisco Fire Department for when unavailability is required for hearsay, statements against interest, former testimony, family history, and dying declaration. Evidence stuff, bias, prejudice, and interest are never collateral matters on cross-exam. And then for consequential damages, they're okay if they're contemplated at the time the contract was made, or more importantly, reasonably foreseeable at the time of the contract. Damages that are contemplated in advance, I usually think of a liquidated damages clause, which also must be reasonable. And then, of course, someone told us to relax and breathe. Someone else said that state workers' comp claims cannot be removed to federal court. Another thing I remember is you do have notice and hearing if they revoke your welfare rights. One of those little nuggets. Vets and caps for executive powers. So remember that the appointment and removal powers of the president are absolute, so they can't really condition it in any way. Vets caps, I know that's from my PowerPoint literally, but I'm not sure I remember exactly what it means. Do you remember exactly what it means, Hannah? The hearing has to be prior to the firing too, right? It can't be a post hearing for that revocation of welfare rights. For vets caps, I don't want to butcher it, but I think it's the veto power, executive orders, treaty power, and special appointment power. I don't know. Caps commander in chief. Here we go. Someone. Oh, appointment and pardon power. Yeah. Caps is commander in chief, appointment, pardon power. Does anyone know what the two S's stand for?
Think it's State of the Union.
State of the Union. All right,
State of-
nice. I like that. So yeah, we have a lot of really, really great pieces from the class. And, you know, like I said, there's ever anything you're like, wow, I can't remember what it is. Vets and caps, that sounds like constitutional law to me. So how would I figure out constitutional law? Well, I would trust that I probably did a pretty thorough PowerPoint because I tend to do pretty good PowerPoints, except this one I forgot to update for July. All in real time, right? Then I always have a bunch of slides about how amazing Ibis prep is. And then we get to the juice, right? And right here, vets and caps. See, I told you I could find it. Veto power, executive power to take care that the laws of the US are faithfully executed. Treaty power, State of the Union, recommendation to Congress for proposed legislation. Commander in chief, appointment power, pardoning power, and power to call special sessions. We actually got them all right. Good for us, guys. All right, I know I'm such a loser. All right, but yeah, there's just some great pieces here. Everyone has been asking this today. I don't know why, but today's been the day of what's the difference between the 10th and 11th Amendment? And if 7 people ask me that in one day, it's got to be something on a lot of people's mind. 10th Amendment is state sovereignty. We are a state. We're allowed to do what doesn't conflict with the federal government. You know, think of commandeering clause, preemption, federalism. These are concepts of state sovereignty, the right for a state to be sovereign. Whereas the 11th Amendment is sovereign immunity. Sovereign immunity means that an individual cannot sue a state. Now, an individual can sue a state officer in their official capacity, and a state can sue a state can consent to being sued. There's some, you know, injunctive relief and different types of tort reform things. There's different reasons you could sue the state sometimes, but generally speaking, the state is immune. That's sovereign immunity. Can a state sue another state? Absolutely. Who would have exclusive jurisdiction? The Supreme Court. Can the state sue the federal government? Absolutely not. And right, I like what we said about 10th. Whatever is not explicitly stated by federal is reserved to the state. Excellent. So now I want to end class with, I think, our latest and greatest contribution to the bar prep game, which is our new questions. So we have 400 plus questions and explanations. They were created by Matt Beckerman, who scored 167 on the MBE, and they're really just to enforce fundamental concepts. Is this something that I would waste time doing over the weekend? Absolutely yes. Would it be a waste of time? Absolutely no. I've gone over these questions and they reinforce a lot of things. There's some questions where I'm a little bit like, is Matt, what was he thinking here? Or whatever. Just skip it. Don't spend time being hey, Andrew, question number 47, la, la, la. Like, sure, send it to me. We'll consider it, but don't let that affect your studies, right? Like, let that affect me and we'll address it, but just use this as a valuable resource. These questions were written by Matt. Matt's a genius. They're mostly perfect. There might be some, you know, it's the law. There's some gray areas. There's some questions I'm like, I kind of think this. I see why Matt would think that. Just use it as a learning basis. So we did some other subjects. Why don't we look at some subject we haven't touched? Real property. Alex conveys a property to Jessica for life, then to whoever is living in the house at the time of Jessica's death. What type of future interest has Alex created? Anyone know in the chat? Right, and someone's saying they ran out of questions, so they're all the same now. Someone's saying B and someone's saying C. We'll look at Alex. Alex has created to Jessica for life, right? Then whoever is living in the house at the time of Jessica's death. So the future interest has Alex created, right? There's no condition. I do like executory interest. It's a third party. Is that right? Let's see what I was thinking here. Oh no. The future interest is contingent because not certain who'll be living in the house at the time of Jessica's death. All right, look. We as a class are learning. I mean, not even learning. We understand vested remainder, contingent remainder, and executory interest. It is a third party, but it's contingent because we're not sure who exactly it's going to be. Greg grants a property to Lisa so long as she uses the property for educational purposes. What does Lisa hold? So long as she holds it for educational purposes. Yeah, everyone's saying B here, fee simple determinable, right? Because so long as it's going to be automatic reversion. The Lisa holds a fee simple determinable because her stay will automatically end and when the condition using the property for educational purposes is breached. David conveys his property to Sarah, but if she ever smokes on the property, then to Jason. What type of estate does Jason hold in this scenario? Shifting versus springing. Let's look at the example here. Springing is when it springs from the grantor to the grantee. Shifting is when it shifts from a grantee to a third party. Who is it going to, what's going to happen here? To Sarah, and then it will shift to Jason. So we could pick C. I gotta start going with my own answers here because you guys led me astray in the first one. Barbara conveys her house to her son, Mark, for life, then to Mark's children who reaches the age of 25. Mark is currently 30 and has 2 children, aged 3 and 7. What type of remainder do Mark's children hold? So her son, Mark, for life, then to Mark's children who reach the age of 25. Mark is currently 30 and has 2 children, aged 3 and 7. This is a tough question. So A's, B's, C's. Barbara conveys her house to her son, Mark, for life, then to Mark's children who reach age 25. Mark is currently 30 and has 2 children aged 3 and 7. What type of Mark's remainder do they hold?
Yeah, I thought rap got into this one.
I think rap too.
That's what
It
I was
would,
saying.
but since there's like no option, I'd go with vested remainder, like the subject to open. No?
I think executory interest. No, contingent remainder. You guys are right. Mark's children have a contingent remainder because the interest is contingent upon reaching the age of 25. Until they reach 25, it's not certain they're inheriting the property. Again, simple answer, right? It's contingent on them reaching that age. Tom conveys a property to his wife, Linda, for life, then to their children. Again, we're trying to just learn, make sure you understand what these concepts are. Tom conveys a property to his wife, Linda, for life, then to their children. Tom and Linda currently have 2 children, Bill and Sarah. What will happen to the property if another child is born after the conveyance? The new child will not have any interest in the property. The new child will share the property equally with Bill and Sarah. The new children will get the property, but Bill and Sarah will be disinherited. The new child will have a contingent remainder. To his wife, Linda, then to both children. Yeah, this one's got to be B. All right, let's do one more real property. Richard gives, again, just for purposes' sake, I'm going to skip through a little bit. So I'm better off just guessing. Does this violate, whatever. I just want to skip through these ones so that we can do something different than this rap thing. All right, let's try this one. Emily is a tenant in a large apartment building. She constantly plays loud music at night, causing several complaints from other tenants. The landlord wants to evict Emily. What must the landlord generally do first before he can evict Emily? File a lawsuit against Emily, provide Emily with a notice to quit, increase Emily's rent to encourage her to move out, wait until Emily's lease is up and then refuse to renew it. What must they generally do? I'm getting a lot of B's here, right? A couple of A's, a lot of A's and B's. File a lawsuit or provide notice. I think notice, right? Before you can evict them, you have to provide notice. Good job. Generally, before a landlord can evict a tenant for violating the terms of lease, they must provide the tenant with notice to quit or cure the violation. Tenant does not comply, the landlord can proceed with the eviction proceedings. Do one more. Heather leases an apartment from Ian. During the lease term, the city condemns the building due to its safety issues. Heather has to move out. Is Ian, the landlord, generally liable for Heather's relocation costs? The city condemns the building due to safety issues. Heather has to move out. Is Ian the landlord generally liable for Heather's relocation costs? Yes, because it's Ian's responsibility to maintain safety property. Yes, but only if Heather can prove Ian was aware of the safety issues. No, because the city, not Ian, condemned the building. No, unless the lease specifically states that Ian is responsible for relocation costs in such situations. No worries, Gabby. We're just about to finish up too. I just was showing everyone what this was. Everyone thinks it's D here. I want to call Matt Beckerman up. So the city condemns the building due to safety issues. Heather's moved out. Is Ian the landlord generally liable for Heather's relocation costs? I would say no, because the city condemned it. I kind of like D. Is this the best answer? Just that it's like, I mean, I don't know. Does anyone know this answer? Let's see. Yeah. Generally, unless the lease agreement states otherwise, a landlord is not responsible for tenant's relocation costs or the property is condemned due to no fault of the landlord. However, laws can vary by jurisdiction. In some places, the landlord may have to pay relocation assistance in these circumstances. You see what I did there? That's a test-taking strategy. Some answers look good, but look for the answer that's like, you know what? If this were true, this makes the most sense. Like, it's not his fault, but if the contract said it, that would make a lot of sense. Let's move on and do a couple. Let's try maybe torts. Actually, too much NID today. Let's try con law. Congress enacts a law prohibiting the burning of the American flag as a means of protest. A protester is arrested for burning a flag and challenges the law as a violation of the First Amendment rights. What is the likely outcome? The law is constitutional because Congress has the power to protect national symbols. The law is unconstitutional because it violates the First Amendment protection of symbolic speech. The law is constitutional because flag burning is not considered speech. The law is unconstitutional because it violates the protesters' Fifth Amendment rights. Yeah, everyone's picking B here. It violates their protection of speech, right? Let's see. The law is unconstitutional because it violates the First Amendment's protection of symbolic speech. The Supreme Court in Texas v. Johnson held that flag burning is a form of symbolic speech protected by the First Amendment. Congress passes a law requiring every state to lower the legal drinking age to 18 or face a reduction in federal highway funding. A state challenges the law, arguing that violates the 10th Amendment. Here we go. What is the likely outcome? The law is constitutional under Congress's spending power. The law is unconstitutional because it infringes on state sovereignty. The law is constitutional under Congress's commerce power. The law is constitutional because it violates the 21st Amendment. Everyone's going with A here. Right, because they're allowed to condition it on federal funding. This is a common situation. The law is constitutional under Congress's spending power. Congress can use its spending power to encourage states to adopt certain policies by conditioning federal funds and compliance with those policies, so long as the conditions are clear and relate to the federal interest. Congress passes a law prohibiting states from implementing environmental regulations that are more stringent than federal regulations. Great question. A state challenges the law, arguing that it violates the 10th Amendment. What is the likely outcome? The law is constitutional under the Supremacy Clause. The law is unconstitutional because it commandeers state governments. The law is constitutional under Congress's power, or the law is unconstitutional because it violates the state's police power. It prohibits them from implementing environmental regulations that are more stringent. We have D and B, or D, or D, or B, or D. I think this is commandeering, right? The law is unconstitutional because it commandeers state governments. The 10th Amendment reserves powers not delegated to the federal government for the states, and the Supreme Court held that Congress cannot directly command states to implement federal regulatory programs or enact specific legislation. A huge point here. These questions are brand new. We brought them out at the last second as an additional study piece. You'll learn more from the explanations in the question. If you feel like the question confused you, give Matt Beckerman a break. The explanations are where you can do a lot of learning. All right, the president signs an executive order requiring all federal agencies to adopt certain climate change regulations. A federal agency challenges the order, arguing that it violates the separation of power. What is the likely outcome? The executive order is constitutional because the president has inherent authority to issue executive orders. The executive order is unconstitutional because it violates the non-delegation doctrine. The executive order is unconstitutional because it falls within the president's power to take care of that the laws are faithfully executed. The executive order is constitutional, I'm sorry. The executive order is unconstitutional because it infringes on Congress's legislative power. So he signs an executive order and they challenge it. Is it constitutional or not? I agree with you, Omar. It seems faithfully executed within their power. The executive order is constitutional because it falls within the president's power to take care that the laws are faithfully executed. The president has broad authority to direct the executive branch, ensure the federal laws are carried out, which includes the power to issue executive orders directing federal agencies. All right, let's do one more subject. Shelby, are you with us? You're still awake, Shelby?
Yeah, I'm here.
What subject do you want to do? Last one. I've known you the longest, so you get to pick. My longest friend. Are you here, Shelby?
Yeah, let's do torts.
Towards. All right, I'm gonna skip around a little bit because I'm sick of the NIED thing. Well, whatever. In the NID claim, which of the following is typically required to establish a duty of care, zone of danger? Wow, look at us, we're smart. Which of the following is not required to establish a claim for NIED? I don't think it has to be outrageous conduct. It just has to be duty breach causation. Right, outrageous conduct is IID, not NID. All right, again, let's get past these. All right, here we go. Let's talk about Farmer Jones. Oh, a large dog, my favorite animal. Farmer Jones has a large dog that he keeps on his farm. The dog frequently barks at people walking by and is not allowed to play with other dogs because it's known to attack them. Not you, Rosie. One day, the dog escapes and bites a neighbor who suffers a serious injury. Which of the following is the most likely basis for the neighbor's claim against Farmer Jones? Here you go, Rosie. Listen up. Strict liability, negligence, trespass or chattels, or conversion. Everyone's picking A, right? Strict liability. You hear that, Rosie? You hear that? If you have dangerous propensities, you're going to be held strictly liable because you're a dangerous animal. You look dangerous. Pet shop sells exotic pets, including venomous snakes. Jane purchases a venomous snake from pet shop and escapes from her home, biting and injuring her neighbor. Which of the following is the most likely basis for the neighbor's claim against Jane? Strict liability, negligence, trespass or chattels, or conversion? It's a snake, right? It's going to be very strictly liable. All right. Let's bounce around a little bit through this Farmer Jones type of activity. And I don't know. I'm just guessing so we can move forward. I just want to do like two more and then we'll call it a day. All right, here we go. Sarah purchases a new blender from Kitchen Goods. The blender's lid pops off while in use, causing hot liquid to spill and injure her. Sarah files a lawsuit against Kitchen Goods. What must she prove to succeed on a design defect claim? The blender was defectively manufactured. The blender's risks outweigh its benefits. The blender lacked adequate warnings. Kitchen Goods acted negligently. I love this question. Matt did an amazing job. B from Amy, right? Right, that's the risks outweigh the benefits. That's exactly a matching situation right here for design defect, hopefully. All right, good. To succeed in a design defect claim, Sarah must prove that the blender's design is unreasonably dangerous and the risks outweigh its benefits. I'm telling you, I think these explanations are amazing. Let's get a little bit past these. I think it's gonna be a lot of products liability. Knowing Matt, he gets stuck on his favorite things. All right. Gary saw his neighbor Helen sunbathing in her backyard. He decided to take a photo of her without her permission, yikes, and post it on social media. Which of the following best describes Gary's liability? Gary is not liable for any intentional torts because he did not physically touch Helen. Gary is liable for invasion of privacy. Gary is liable for assault because he intended to cause emotional distress. Gary is not liable for any intentional torts because the photo was taken from his property. Everyone's saying peeping Tom, peeping Gary, gross Gary. All right. I know I said that was going to be the last one, but you know me. In which of the following situations would defensive necessity likely be successful? A person steals food because they're hungry. A person breaks into a house to escape a sudden and severe thunderstorm. A person drives over the speed limit because they're late for work, or none of the above. Bees are coming in. Severe thunderstorm, excellent. The doctrine of merger applies to which of the following crimes? Solicitation and conspiracy, not conspiracy, attempted conspiracy, not conspiracy, attempted completed crime, potentially, conspiracy, not conspiracy. It's got to be attempted completed crime. All right. Last question. Let's see if anyone learned anything today. Which of the following is a specific intent crime? Assault, battery, burglary, or false imprisonment? Wait, I don't like this question.
It's because false imprisonment, I don't think it's false pretenses.
Yeah, I'm sorry, false pretenses. Okay, so it's gonna be burglary, but assault could be too, right?
Yeah,
Right.
yeah, so I think assault, this was one that was a specific intent. Assault was also maybe, no,
Attempted assault.
the answer is C, but yeah.
Burglary, specific intent, just a thing to know that assault can be specific intent. All right, last
Exactly.
one. Which of the following statements about the defense of duress is correct? It is a valid defense to homicide. It requires a threat of imminent physical harm. It is based on the defense mental illness. It requires a reasonable belief that the threat is unavoidable. Everyone is saying D, 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 D. Hello?
You froze a little bit, Andrew, but we're here.
Do you remember the
OMG.
answer? Do you remember the answer to that, Scout? Do you remember the answer to that one, Scarlett?
I don't remember because I didn't do it, but I believe it's D because it is not a valid defense to homicide. You can't, even if you're being threatened, from what I remember, or under duress, they can't be like, okay, shoot this guy or I'm gonna shoot you. Like you can't, that's what I remember from learning, but that's why I knocked out A.
All
You're
right,
right.
well,
It requires physical harm either.
I'm not gonna leave everyone super hanging. Don't worry, we'll get to the bottom of it. Thank you all for bearing with me. Let me just share my screen. And we'll go back to it. So it was, and see, look, right now I'm doing it on my phone. This is really easy. You could just load it up on your phone, do some questions, boom. All right, but I'm not sure we're gonna get it right or wrong. Which of the following statements about the defense of duress is correct? Is a valid defense to homicide? No. Is a valid, it requires a threat of imminent physical harm. I like that one. Is based on defendant's mental illness? Oh no, it has to be imminent physical harm, right? Not necessarily. It just has to be a threat. And it requires a reasonable belief that the threat is unavoidable. I kind of like D. Is that what everyone liked?
Yes. Everybody picked, well, not everybody.
The answer is D. It requires a threat of imminent physical harm. The defense of duress requires a threat of imminent physical harm, causing a defendant to commit a crime they would not have committed otherwise. Duress is not a valid defense to homicide, is not based on mental illness, and requires an imminent threat rather than a reasonable belief. Excellent question. It doesn't have to be a reasonable belief to be duress. It has to be a imminent threat. So again, decent questions. We're never going to end on a wrong question, though. No chance. What distinguishes first-degree murder from second-degree murder? Intent to cause serious bodily injury, negligence, malice aforethought, or premeditation and deliberation? This question doesn't make sense either, right? It depends on the jurisdiction.
I'd go with D.
Yeah, I would go with D too.
I just don't really understand this question. We're gonna do another one. Good job. The first degree murder is distinguished from second degree murder by the presence of premeditation and deliberation. Both first and second require malice aforethought, but first degree murder involves a planned intentional killing. Only reason I don't love this question is because jurisdictionally it could be a little bit different. Which of the following is an essential element of the crime of arson? The intentional burning of a building, the use of accelerant to start a fire, the destruction of personal property, or the burning of a building for financial gain? A, right? Or the burning of a building for financial gain, or the intentional burning of a building. What do you guys think? Oh, sorry.
I do know with arson, it has to be charring. It can't just be like smoke, right? Like it has to actually
Right.
like
Actual
Char.
charring, more than just discoloration. I do think it's intentional, right? It's got to be intentional.
Yeah, because wouldn't D be a different crime?
The essential element of the crime of arson is the intentional burning of a building. Arson requires a willful, malicious act of setting fire to a building or structure. The use of an accelerant, destruction of personal property, or financial gain may be relevant but not essential. We'll do one more criminal law one. In the context of criminal law, embezzlement is defined as the taking and carrying away of another's property without consent, the fraudulent conversion of another's property by someone in lawful possession of that property, the obtaining of another's property by false pretenses, the trespassory taking and carrying away of another's property with the intent to permanently deprive. So this is larceny, this is false pretenses, and this is larceny
Robbery.
as well.
Conversion? Ooh, that's what
Right.
Isn't D
Gotta be.
robbery?
Yeah, well, D would be robbery if it was by force. I think D and A are both elements of larceny, but B sounds like embezzlement, right?
D wouldn't be conversion?
No, that's larceny. I think.
Oh,
Well, I know A is larceny. I thought D would be a form of conversion as well when you intend to permanently deprive of it.
I think they're both part of larceny, A and D.
yeah, I think A and D are both part of larceny. You said conversion. Conversion is civil, so it wouldn't just it wouldn't be
okay.
proper.
I just thought in general. General about
You're
the
not wrong
definition.
because literally the way I explain it to a lot of people is that larceny is criminal
civil.
conversion. Yeah.
Yeah.
We didn't do civ pro, did we? So
Yeah.
we did.
Can we do evidence?
All right, fine. We'll do evidence. We'll end on evidence. Evidencia. What is the purpose of the hearsay rule in evidence law? To prevent speculation and conjecture by requiring firsthand testimony, to ensure the reliability and accuracy of evidence presented in court, to prohibit the introduction of prejudicial evidence that is not relevant, to limit the scope of cross-examination by opposing counsel. Hearsay rule? What do you think? Is everyone there? Am I frozen?
Yeah, so a majority of people are putting B.
Oh, B, sorry,
Yeah,
I can't
that's
see the chat
yeah,
right now.
B.
Yeah.
Oh,
Yeah.
sorry. Okay.
Sorry, if someone could just announce the chat, I can't really see it. Which of the following is an example of hearsay evidence? Testimony from a witness who personally observed an event, a document that was signed by the defendant, a statement made by a person who was not available to testify in court, expert testimony on a technical or scientific matter. See?
They will be seen. Yeah.
A statement made by a person not available in court. Which is the standard of admissibility of scientific evidence in court? Fried, Daubert, hearsay, or best evidence rule? We got to go with the Daubert standard. Right? These are fire questions. Like, you know, you go do a bunch of official MBE questions and you're going to be reading about smoking hairy loose wort or like doing, you know, the weirdest stuff ever, and it's going to scramble your brain. These questions will direct you right to some rule statements. What is the best evidence rule in evidence law? I took the hairy loose wort test. That's not on questions. That was a real test. So what is the best evidence rule in evidence law? It requires the introduction of the original document or recording rather than a copy. It requires a party to produce all evidence in the possession related to the case. It prohibits the admission of hearsay evidence in court. It requires all evidence to be authenticated before it can be admitted in court.
A, yeah.
The only thing is a photocopy is okay, but I do think A is the best answer here. Yeah. It requires your introduction rather than a copy. But again, most photocopies are okay. Which of the following is an example of a character witness? A witness who testifies about the defendant's reputation in the community, a witness who testifies about the defendant's past criminal record, a witness who testifies about the defendant's state of mind at the time of the offense, a witness who testifies about the defendant's involvement in the offense.
A.
Yeah. Gotta be A. I like A. Which is the confrontation? What is the confrontation clause in the Sixth Amendment to the U.S. Constitution? It prohibits the use of illegally obtained evidence in criminal trials. It requires a defendant to be present in court during trial. It guarantees a defendant's right to confront and cross-examine witnesses against them. It requires a unanimous verdict in criminal trials.
C.
C, right?
Yeah.
Yeah. Confrontation, to confront. Confrontation. We'll do one more evidence. Which of the following is an example of impeachment evidence? Evidence as used to prove a fact at issue in the case. Evidence as used to show that a witness is biased or has a motive to lie. Evidence as used to show that a defendant acted in conformity with their character, or evidence as used to show that a witness is qualified to testify.
B.
B.
Yeah. All right. Evidence is used to show. Oh, did we do it? Pretty much everything in class today? Let's take a peek at the Crim Pro. All right, fine. Last subject, I promise, because I have a student after this. Detective Martin obtained a warrant to search Carla's house for stolen property related to a series of burglaries. The warrant specified that the search should be conducted between 6 a.m. and 10 p.m. Due to an unforeseen emergency, the detective arrived at Carla's house at 10:30 p.m. and conducted the search, finding stolen property. Carla moves to suppress the evidence. Will the court grant her motion? Yes, because the search was conducted outside the specified time frame. Yes, because the emergency had validated the warrant. No, because the search was only slightly outside the specified time frame. No, because the warrant was still valid at the time of the search. Did anyone answer?
E.
Yeah, A.
I think A2, right? The search warrant specified that it had to be between 6 and 10, since it was conducted outside the time frame, it was non-compliance, and would likely be suppressed. If you don't believe that, don't worry. Next question. Officer Lopez arrested Tim for assault and placed him in the back of the patrol car. Before reading his Miranda rights, Officer Lopez asked him if he had any weapons on him. Tim responded that he had a knife in his pocket. The officer then recovered the knife. Tim moves to suppress the knife as evidence. Will the court grant his motion? I'm gonna be honest, I only know this question because I did it earlier and I think I got it wrong. So you guys might not get it wrong either. Yes, because Tim was not read his Miranda rights before being questioned. Yes, because Tim was in custody at the time of questioning. No, because the question was related to officer safety. No, because Tim voluntarily disclosed the information. The answer is going to be C, according to Matt Beckerman, that this is officer safety. And again, was he really in danger in the back of his car? I'm not sure, but there's gray areas of law. Trust me. Trust me. So the officer's question about weapons falls under the public safety exception to Miranda, which allows police to ask questions related to safety concerns without first reading a suspect their rights. All right, let's call this the very last question, I promise. Officer Brown observed Jack driving erratically and pulled him over. Suspecting Jack might be intoxicated, Officer Brown asked Jack to perform a field sobriety test, which Jack failed. Jack was then arrested for DUI. At the police station, Jack requested an attorney before taking a breathalyzer test. The police did not provide Jack with an attorney and administered the breathalyzer test without his consent. Jack moves to suppress the breathalyzer.
You froze, Andrew.
No, because Jack does not have a right to counsel during a breathalyzer test, or no, because Jack was lawfully arrested for DUI. This is a good example of a question that you're like, wait a minute, he was forced to take a breathalyzer test? That doesn't sound right or wrong. I'm learned that you go with the right answer of law. You don't have a right to counsel during a breathalyzer test. So that's just a rule of law that we can learn from this. The right to counsel does not apply to the administration of a breathalyzer test, as it's considered a routine part of a DUI investigation and not a critical stage where counsel is required. Nina was arrested for shoplifting and brought to the police station for questioning. After being read her Miranda rights, Nina agreed to speak with the police about an attorney. Okay, she agreed. During the questioning, Nina confessed to the shoplifter. Later, she moved to suppress her confession, claiming she was too upset and tried to understand her rights. Too upset and tired to understand her rights. Will the court grant her motion? No, because Nina was too upset and tired to understand her rights. Yes, because the police should have provided Nina with an attorney regardless of her waiver. No, because Nina voluntarily waived her rights before speaking with police. Or no, because the police read Nina her Miranda rights before questioning her.
Yeah, C.
C, she voluntarily waived them. Excellent job. And I think it's a great place to end is with that confidence that we understand that if you voluntarily waive them before speaking with the police, then it's going to be admissible in court. All right, so everyone can see me. I got Sam's shirt on. Sorry, I'm in bar prep. I really think that this was an amazing MBE course. I know we were supposed to end last week, but I wanted to just go one more day and I wanted to give you guys some extra resources. So please take advantage of those flashcards, take advantage of that interactive Q bank, and take advantage of tomorrow, Saturday, Sunday. Those are all really good days to study. Monday, Tuesday, you kind of want to wind things down, get good night's sleep, and put yourself in a really good position to perform on test day. If you need anything at all, don't hesitate to reach out, message us in the Telegram chat, email us questions up until the last minute. We're here to help in any way possible. So thank you all so very much.